This is Bloomberg Law with June Grasso from Bloomberg Radio.
Marijuana is now legal in 24 states for recreational purposes and in 38 states for medical reasons, but it's still illegal at the federal level. Marijuana is also increasingly popular. A Gallup poll last fall found 70% of adults support legalization. That's the highest level yet recorded by the polling firm and more than double the roughly 30,000 who backed it in 2000. The White House knows this is an issue that can help win over the support of Americans, especially younger voters, ahead of the election. So in March, we saw President Joe Biden praising his marijuana initiative in his State of the Union address.
Directing my cabinet to review the federal classification of marijuana and expunging thousands of convictions for the mere possession, because no one should be jailed for simply using or having on their record.
And Vice President Kamala Harris hosting a White House meeting to discuss federal marijuana law reform.
On the schedule currently, marijuana is considered as dangerous as heroin. Marijuana is considered as dangerous as heroin and more dangerous than fentanyl, which is absurd, not to mention patently unfair.
Now the DEA is proposing to shift marijuana from what's known as a Schedule I drug, which includes heroin and LSD, to a less tightly regulated Schedule III drug, which includes ketamine and some anabolic steroids. But what will that rescheduling really change? Joining me is David Pozen, a professor at Columbia Law School. His new book is entitled The Constitution of the War on Drugs. David, tell us about this rescheduling of marijuana.
Yeah, the big news from last week was that the Justice Department is now recommending, for the first time ever, that marijuana be rescheduled from Schedule I of the Controlled Substances Act, the most restrictive schedule, complete criminal ban at the federal level, to Schedule III, which is less restrictive and can allow doctors to prescribe drugs in that schedule. But it's actually going to be a much smaller change in people's lived experiences than I think many hope and expect, because although Schedule III substances can be prescribed by doctors, they can only be prescribed if they're also approved by the FDA. And the FDA has not approved marijuana and isn't likely to do so anytime soon. So we're not actually going to move in the foreseeable future to a medical marijuana regime at the federal level. We're just going to move to a slightly less punitive regime, and the action will continue to take place in the states mainly.
So how does this help then?
It helps in one very concrete way, which I'll describe in a moment, and then I think it also helps at a cultural level, if you will. So the concrete effect that it will have is there's a provision of the tax code, Section 280E of the Internal Revenue Code, that says that businesses that traffic in Schedule I or II substances can't get an ordinary business deduction. So they get penalized in that special way. When marijuana is moved over to Schedule III, and I should say that right now it's just a recommendation from the DOJ, but it's almost for sure that that will be accepted in the coming months. So once marijuana is moved to Schedule III, then companies that deal in marijuana and have licenses in their states will no longer get hit by that federal tax penalty. They can take a deduction. So it will be good in a very real material sense for a lot of marijuana companies, this move to Schedule III. That's the biggest legal upshot, I think. And then at a cultural level, you know, the Justice Department and the Drug Enforcement Administration, which is housed within it, has fought marijuana liberalization tooth and nail for decades. So to see the DEA, you know, the heart of the drug control apparatus, go along with a move to a less restrictive schedule is a big deal and could presage the ultimate endgame here, which is federal legislation that effectively legalizes marijuana, moves it to like an alcohol and tobacco kind of status in the coming years. This, in other words, might be more of a way station than a final resting point for marijuana regulation.
President Biden called for a review of federal marijuana law in October 2022, pardoned thousands of Americans convicted federally of possessing the drug. I mean, why not go further? Why this intermediate step? It seems like it's well past time.
It's an interesting question, why he's not going further. He has done more than any president really since Carter to push for marijuana reform. President Carter openly supported decriminalization. And since then, no president has done anything like that. So the fact that President Biden's been willing to issue these mass pardons, he's urged governors to do something similar for simple possession offenses in their states, and now applied pressure on the Justice Department to reschedule marijuana, that puts them in the vanguard of our history of modern executives and their response to marijuana. So I imagine that he's just proceeding incrementally, kind of testing the waters, seeing how his moves are responded to. And I do imagine that if he's reelected, he will come out for full legalization at some point. But I can't get into his mind. But I assume he's just trying to be kind of cautious. And maybe he's also betting on the fact that marijuana politics keeps evolving in a pro-liberalization direction. Gallup does polls every year on what people think about legal medical marijuana, recreational marijuana. The numbers have been ticking up for years now. So it may also be that he's waiting until it becomes even more popular than it already is.
So I assume that because marijuana is used for medical purposes, that it was pretty safe as far as these kinds of substances go. But in some research I did for this interview, I found that the American Heart Association issued a warning on the higher risks of cardiovascular events associated with heavy cannabis use. So that was based on a National Institute of Health study that found that daily use of cannabis was associated with a 25% increased likelihood of heart attack and a 42% increased likelihood of stroke. Is that part of the reason why they're not they're not going to, or it's sort of something that I don't think most people realize that.
I would say a few things. Marijuana is a psychoactive substance. As such, it is not risk-free. No drug is. And there's now a very large body of literature on marijuana's effects, and it's hard to summarize. But at the same time that they found a number of medical benefits, for example, for treating nausea for cancer patients, there are certainly risks, mainly for adolescents, also pregnant people, people driving, of course, and then smoking. Smoking anything over a long time period isn't great for the body and particularly the lungs. And so I can't speak to the specific study you're referencing, but I would say it's a mixed bag, and it's not the case that this is a completely benign substance, but at the same time, it's significantly safer than other Schedule I drugs like heroin, not to mention Schedule II drugs like fentanyl, and unscheduled drugs like alcohol and nicotine, which it's on pretty much any measure safer than. So what do you do with a substance like that is not the most dangerous by any means, but not risk-free? I think there are a lot of strategies to deal with that really aren't well served by putting it in Schedule I and making it illegal. I think because, of course, marijuana is being smoked in huge amounts and was even before it was legalized at the state level, I think the federal government could be more helpful here in dealing with those public health concerns by helping states crack down on illegal dispensaries that may sell to minors, promoting research and educational programs, putting labeling and potency caps, on the sale of marijuana, and taking any number of other measures in a public health framework to kind of limit the downside risks of marijuana, especially for younger people. But that's a different sort of regulatory response than what we're seeing. Moving it from one administrative schedule to another doesn't really address what I think are the real public health concerns here.
24 states have legalized recreational marijuana for adults, and an additional 14 states allow medical marijuana. How will this affect those states?
What is happening right now with the rescheduling of marijuana will do little, really. The states that have legalized marijuana in any form have already gone beyond where the federal government's going to end up. And so they will continue to be acting inconsistently with federal law. Congress and the Justice Department have basically agreed to look the other way on legal marijuana business in all of those jurisdictions. But that's going to stay in the same precarious equilibrium where it is now. And still, marijuana companies are going to operate in the shadow of criminal sanction with limited access to banking services, intellectual property protection, contract enforcement, and all the other standard corporate law privileges that legit companies get. So they're not going to be fully satisfied with this, notwithstanding the tax break. So I guess another thing to highlight about what's happening here is we will continue to have an incoherent regulatory response to marijuana across the state and federal levels, even after it's rescheduled.
Do you think, in this, I guess, is along with the cultural changes, do you think that having this federal change will help in states where there are ballot measures seeking to legalize marijuana?
Interesting. There, if it helps, I think it will be in a kind of atmospheric manner, which is to say, getting the imprimatur of the Justice Department and the DEA that marijuana really hasn't been as dangerous as you've been told and deserves to be moved down 2 schedules. Maybe will trickle down to state politics and help people at the margins feel a little more comfortable with moving toward legalization, realizing that some of what they've heard about marijuana's dangers has been overhyped. I don't know how much, ordinary voters actually pay attention to these rescheduling decisions or what they make of it, but that would be the mechanism, I think, a cultural one. There's no direct bearing on the ballot measures.
Does this pose any problem for our international treaty obligations and the Convention on Narcotic Drugs? Is that a problem that was cited during the Obama administration, that it requires the criminalization of cannabis?
There's a debate on that issue. I don't think it's right that those conventions need to be read to criminalize even personal possession and use of marijuana. But they do seem to forbid having a fully legal market where it can be sold lawfully in countries that have signed those treaties. And so as we move toward legalization, not just rescheduling, we're going to run into those treaties. But actually, we already passed that point. The fact that all of the states in the U.S. have legalized marijuana on their own, the International Narcotics Control Board that administers the UN drug treaties says that we're already in violation, that it doesn't matter that they're subnational units, you're still responsible for them. So we're already operating in what the treaty administrators consider a breach. And so are other countries. Canada just openly announced that it is in violation of these treaties by legalizing marijuana. Germany's about to legalize marijuana, and a lot of other countries through their courts have effectively decriminalized marijuana as well. So we're increasingly moving to a bipolar world, I think, on drug policy, where liberal democracies, through their legislatures and courts, are increasingly decriminalizing, if not fully legalizing, marijuana and also some psychedelics. Other countries in the UN regime, like China, Russia, a bunch of countries in the Middle East and Africa, are absolutely not legalizing their drug policies. In fact, they're doubling down on the severity. So it's going to be very unstable and very unclear where it heads in the coming years at the international level on drug policy.
You wrote in a piece for Time magazine that American drug policy has been characterized by cycles of racialized moral panic and reactionary legislation, punctuated by periods of liberalization. Can you give us a short history?
I'll try. We get the first big wave of prohibitory drug laws in the early 1900s around opium, cocaine, marijuana, alcohol. And there was a strong racialized dimension to a lot of those laws, and specific drugs were associated with specific racial groups, which were then demonized. And then that pattern repeats itself with slight variations as the 20th century goes on. So, for example, penalties against heroin are increased drastically in the 1950s at a time when heroin was associated with Black Americans and other racial minorities. And then we have, of course, in the 1980s, the panic around crack cocaine also had an obvious racial dimension. And then in periods where we've had liberalization, there's often been what you might call a whitening of the drug's racial valence. So marijuana, for example, when medical marijuana starts to take off in the late 1990s and the early 2000s, is depicted as, kind of associated with AIDS patients, HIV/AIDS patients, and is pushed by kind of older white Americans who change the complexion, if you will, of how marijuana is perceived in the response to the opioid crisis that we've been having. That also has affected many white Americans, and some people suggest that has led to a more liberal response. Not a very crisp answer, but just to say that we've had a number of periods of extremely harsh legislation against drugs. It's a moral panic and often also a racial panic when that happens. But then we kind of re-equilibrate and cool off, And there are these moments, like in the 1970s, which my book focuses on, where humane, evidence-based drug reform is possible again. And it's hard to characterize the present moment. There's already been a backlash against what Oregon tried. But we may be in a moment of liberal possibility again. And there, the suggestion the book makes is that constitutional law can help entrench policy gains when they're won. And it can't solve most of our drug problems, but it might be able to prevent against future backsliding if we move to extremely punitive responses in the future.
What's the next step in the regulatory process?
If we're talking about marijuana rescheduling, that's going to move over to the White House, effectively. The Office of Management and Budget will review the proposed rescheduling, and given that the Department of Health and Human Services, the Drug Enforcement Administration, and the Justice Department itself have now all lined up in favor of rescheduling, I would be shocked if the White House pulled back on that. So I think what we'll see is we'll have a notice and comment period where the members of the public can submit their views on this proposed rescheduling, and I assume lots of people will. And then I expect it to go forward and become law sometime in the coming months.
I mean, so the Senate has introduced legislation to legalize cannabis on the federal level. I think it was a bill originally introduced in 2022. I don't know if it's exactly the same. That's unlikely to get passed with this Congress. How does that fit in with the scheduling of marijuana?
So right now, it's still going to be a scheduled drug under the Controlled Substance Act. And the big change that could happen that would require congressional legislation, not just this administrative move within the executive branch, would be moving it out of the Controlled Substance Act altogether. In other words, not just rescheduling, but descheduling marijuana. And then it would be treated, I assume, on the model of alcohol and tobacco, which is to say there would still be age minimums, there would still be taxes, it could be controlled through zoning, licensing, and it would by no means be, total laissez-faire. Everyone gets to buy their pot. But it would be like an alcohol or tobacco model that has already passed the House. And as you suggest, the hang-up is in the Senate. I have no crystal ball into what's going on in the Senate, but I do see the polling numbers, and it seems to me that sooner than later we'll reach a point where it's going to be hard for senators to hold out much longer. Barring some major, cultural shift, we are heading to a place where marijuana will get legalized. Who knows? In the coming decade, let's say.
And tell us a little about your book.
The book is a history of how people have fought punitive drug laws on constitutional grounds throughout U.S. history and had surprising success in doing that, raising arguments about privacy, liberty, freedom from cruel and unusual punishment, free speech, and so on. And so it's not really about scheduling decisions so much as constitutional law and how people made rights claims about drugs that actually got taken very seriously in prior generations and have fallen out of the conversation.
And the title of the book, again, is The Constitution of the War on Drugs. Thanks so much, David, for being on the show. That's Professor David Pozen of Columbia Law School. Turning now to the Supreme Court. We've heard a lot in the last few years about the shadow or emergency docket of the Supreme Court. Well, now it appears that the U.S. Solicitor General is complaining about it, or at least its effect on her office. Joining me is Bloomberg Law Supreme Court reporter Kimberly Strawbridge Robinson. Kim, tell us how the shadow docket has grown in recent years, both in size and in importance.
Sure. So the shadow docket has always been around. It deals with certain emergencies, and there's always been emergencies for the Supreme Court to deal with. But usually up until about a decade ago, it was mostly just death penalty cases, where the Supreme Court had to step in right away because there was an execution that was about to take place. So what we've seen, though, over the last decade is, as you said, June, that it's really been growing. And the kinds of cases that we see on it are no longer just death penalty cases, but often very significant policy questions from either state or federal governments. And we saw it really peak in the pandemic, which may be expected. Of course, there were all these, new and novel ways that states were trying to deal with the coronavirus. And, those were being challenged in courts and making their way to the Supreme Court. But, as that pandemic has sort of gone away, we haven't really seen the shadow docket cases go away. And so now, every term there are a number of very significant cases that work their way up through this very expedited procedure on the court. And it's just taking up more and more of the court's time and more of the lawyer's time.
Well, this term, one of the biggest cases of the term was on the shadow docket, the Colorado ballot case.
That's right. I've been covering the court now for more than a dozen years. And, for the first half of that, it was very unlikely that we'd get a case that, was sort of taken off the emergency docket and given full briefing and hearing. Now, not only is it that case, but we have 4 other cases, including, a challenge to Idaho's abortion ban. And so, we see it sort of taking up more and more oxygen in the room, these cases that, come up in a very quick and expedited fashion and often aren't given the same kind of time to work their way through the legal system that we traditionally think of.
And it was really interesting. The Solicitor General, who represents the United States before the Supreme Court when the federal government is a party, she said it's one of the biggest shifts in the court's work, and it's changed the function of line attorneys at our office.
Yeah, she said, before being the Solicitor General, it's an appellate gig. And so things sort of have a natural life, a timeline that they operate on. And now, things can move much more quickly on the emergency docket. And she needs people who can, not spend months writing a brief, but, sometimes a week or two writing a brief on a very significant thing from, Colorado ballot to Idaho abortion to, name anything that's especially important, and it seems to find its way up to the Supreme Court. So, yeah, it's not only changing work for the justices, but it's changing the work for the people who operate before it.
Is the Biden administration partially responsible because, like the Trump administration, it's bringing more cases to the shadow docket?
Well, that is true that a big number of these cases are cases brought by the federal government, whether it be under Biden or under Trump. But, Solicitor General Prelogar said that that's really not anything that the Biden administration can do about it. If the lower court is going to put a federal law on hold, particularly if it's going to put it on hold for the entire nation, it's not something that the Biden administration can say, okay, well, we'll wait and see, 2-3 years from now what we can do about it. That's something they're going to go to the justices and ask for help right now.
She said that the cases unfold at a rapid-fire pace and put the court in a position of making high-stakes decisions with incomplete information.
Yeah, I think we've talked about it a couple of times, but that Colorado ballot case is a really good example of that. This was a case that had been to trial, worked through trial, but then sort of got an expedited path up to the Supreme Court. And, within a matter of months, the justices are not only having this case come to them, but they had arguments. They had to write an opinion about an area of the law where there really wasn't any law on it before. It's something, that they kind of had to start fresh with and on a very expedited timeline. And of course, these things matter a lot. Things like, the Trump ballot case, Idaho abortion, and other things that we're seeing coming up through the shadow docket.
So also on this ABA panel discussion was former Solicitor General Paul Clement, and he said it's partially the court's own fault.
Well, I think what he meant by it was that the court has been agreeing to take up a lot of these cases, and so if they're asked over and over and over again to intervene, and the answer is always no, we're going to let the lower court do what they do and wait for them to act, well, then people probably wouldn't feel the urge to ask the Supreme Court. But because they do grant a number of these shadow docket requests, I think Clement's saying that they sort of bring it on themselves. The court itself is sensitive to these comments, and unusually we saw in a shadow docket order, we saw a number of opinions on this and how the justices seem to feel about this idea that they've brought this on themselves.
I hadn't heard this before. You quote Justice Sonia Sotomayor says she's working harder than I ever had.
Yeah, she said in January that the shadow docket, just the number and the sheer weight of the consequences of them, she said, look, I'm almost 70. I never thought I'd be working this hard. And she said, I'm tired. So me too. But
right.
She may have a better reason than I do.
We're all so tired waiting for all these decisions. And coming up, we're going to talk about them. I'm June Grasso, and you're listening to Bloomberg. I mean, the decisions in most of the controversial cases are yet to be handed down. Cases involving, for example, abortion, guns, elections, and agency power. The oral argument sessions are over, and we've been waiting for some of these decisions for a while, some not so long. First, the cases having to do with Trump and the presidential immunity case that they set for the last day of oral arguments. Did they add a day to the calendar for that?
They did, yeah. They added a day for that. That was the last argument that they heard, and now they're turning to try to get out all of these opinions, in which they have more than 36, and you're hinting at the immunity case. But this year's docket was just so full of blockbuster cases that could have these potentially huge impacts.
Really? And so there are, I think, two that affect former President Trump. There's the presidential immunity case and also the case over the obstructions charge.
That's right. And that's, not a case that personally involves the former president, but it could possibly affect some of the charges that have been brought against him. And in particular, it's whether or not prosecutors just got too creative and went too far in charging this obstruction charge, which carries, a pretty hefty 20-year sentence. We haven't seen anybody get that much time for this yet, but, it's just the idea of being able to use a charge like that, whether or not it's appropriate or whether or not they're sort of bringing more to bear than what the statute can handle.
And then there are two abortion cases, one over the pill, mifepristone, and then Idaho, which you mentioned, the Idaho ban.
Right. The mifepristone case really seemed like one that might actually just sort of go away. A lot of the justices seem to think that the parties who had brought the case weren't the proper people to really be challenging this kind of law. So it may sort of get tossed on, a technical ground. But, the Idaho case seems like the justices are really divided on the merits of that dispute. And, it's going to be really significant. This is the first abortion state law, a state ban that the justices are considering since it overturned the right to federal constitutionally protected right to an abortion. So very significant for what it will mean going forward and what states can do.
And what about Second Amendment cases?
That's right. So we heard, sometimes I forget that some of these cases happen. They're chock-full.
And I sometimes think, well, wait, was that this term? Was that last term?
But there are a couple of significant Second Amendment cases. Early in the term, they heard a case called Rahimi, which was about whether the federal government can limit gun possession by those who are subject to a domestic violence restraining order. The justices seemed like they were going to okay the federal law there, but there's probably more that they're writing about, upcoming challenges. So, we'll see what they have to say about that one. And then there's another one on bump stocks and whether or not the administration could define bump stocks as machine guns and therefore ban them. So a couple of really significant Second Amendment cases as well.
See, I forgot the bump stock one. It's a long term and the decisions are so slow to come out. As far as elections and congressional maps, is it just the South Carolina case about racial gerrymandering?
Yeah, it is right now just the South Carolina case that's pending before the justices. I think, we started on with a conversation, though, about the shadow docket. And as we're coming up on, what is not just an election, but a pretty contentious presidential election, I suspect that we'll see a lot of shadow docket cases on elections, whether they be state elections or federal elections. But I'm sure they're going to be working their way to the court.
So now we have a case involving the Chevron doctrine, which we love to talk about. I don't know if people love to hear about it. A legal doctrine that gives federal agencies wide berth to interpret unclear laws. And it's about a National Marine Fisheries Service requirement. It's about fish.
Well, the two cases that are in front of the justices do involve fish. But, I'm not exaggerating here when I say that these cases have the potential to touch nearly every aspect of American life because administrative law and federal agencies do so much. And this ruling does have the potential to sort of change how those decisions get made. And in particular, it's whether or not sort of courts should have the final say on what an unclear statute means or whether or not it should be expert agencies. And, the justices during arguments were very split on not only, what they should do going forward, but what the doctrine even means and is supposed to do. So that's one that I'm guessing is going to take a long time for them to get out. But we're eagerly watching just given the impact that it could have.
To completely do away with the doctrine would cause so much upheaval. And, some of the justices have been angling at that for years. But there are so many consequential cases this term. It might be a bad idea to do that as well. We'll see. So then, involving agency power, the Securities and Exchange Commission's use of in-house judges.
There really have been a lot of these agency decisions where the Roberts Court, particularly with the 3 Trump appointees, have sort of been nipping and tucking at agencies and what they can do and how they can operate and how they interact with the regulated public. This is another one of those cases which could do away with, or at least change dramatically the way that, these in-house judges work for the SEC and, potentially other agencies. So it's another one we're watching. It's another one that in any other term would be, one of the first cases we talk about. But in this term, we talk about it much later.
Would we put the case about the Consumer Financial Protection Bureau in the same category or a different category?
Yeah, I think that one, goes along with the SEC case, along with the Chevron doctrine that we've been talking about. That one is about the funding mechanism for the CFPB and whether or not Congress got a little too creative when it tried to sort of keep that agency independent. Again, it's another one, that was argued very early, but where we see the justices really divided about what Congress's powers are, what the executive's power is through agencies and sort of accountability. So these sort of fundamental ideas that the justices are debating. And, that one was argued in October. We still don't have an opinion. So it says that they're having a pretty fierce debate about it.
Was it 2 cases on social media content? One from Texas and one from Florida?
There are actually a lot of social media cases this term, but there were those pair of social media cases talking about really what states can do to these social media companies who, of course, are not governments and are so really not subject to the First Amendment, whether or not, states can sort of tell them how to run their business or whether or not, they get to decide. So those are 2, again, out of Florida and Texas that we're closely watching, but there's some other social media cases, some that have been decided about, sort of how First Amendment works when it's the company kicking people off of the platform rather than a government. And there's another social media case involving the Biden administration's sort of efforts that it took to counter what it saw as misinformation online. And so a lot of stuff about social media. It seems like the Supreme Court's finally moving into the 21st century.
Yeah, it used to be that they were very confused when things about social media came up, and now I guess they're used to it. There's that historic, the Purdue form of bankruptcy settlement. That's a really interesting case.
Yeah, this is a multi-billion-dollar settlement over Purdue and its drugs and whether or not it was responsible for a lot of the problems that we're seeing now with narcotics and addiction in the country. And, this case is really interesting because it's not the parties that are really objecting to the settlement, but it's the federal government. And the question is, well, does the federal government get to say, whether or not the settlement can go through, or is it sort of just more of a quiet party? So we'll see. Again, that one was argued a few months ago, so we could get an opinion. But again, I think just given the stakes, it's going to take them a while to sort of sort out what they want to say there.
They have been really slow handing down decisions. Only 18 of the 62 cases they've heard.
They're getting slower and slower, so this year isn't out of step with some of the other terms. But, if we were to step back like 10 years ago, yes, it would seem slow, but they're pretty much on target, and they'll just flood us the last 2 weeks of June with every important decision ever made.
As they always do. They drop all the major decisions and then go on vacation. Thanks so much for that rundown, Kimberly. That's Bloomberg Law Supreme Court reporter Kimberly Strawbridge Robinson. In other legal news today, in Donald Trump's hush money trial, Judge Juan Merchan ruled for a second time that Trump was in contempt of court for violating a gag order. He fined him $1,000 and warned that he could jail him for further violations of the order, which is intended to protect witnesses as well as jurors. Former Comptroller Jeffrey McConney was on the witness stand today, offering jurors their first detailed look at how Trump reimbursed Michael Cohen, his one-time lawyer. Trump used a personal bank account to repay most of the money he owed to Cohen, who bought the silence of adult film star Stormy Daniels before the 2016 election. Trump is on trial for allegedly falsifying dozens of business records to conceal the $130,000 payment to Daniels. Jurors saw invoices, company ledgers, and checks documenting how Trump paid $35,000 a month to Cohen in 2017 while he was in the White House. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast. And attorneys looking for legal research? Whether you're an in-house counsel or in private practice, Bloomberg Law gives you the edge with the latest in AI-powered legal analytics, business insights, and workflow tools. With guidance from our experts, you'll grasp the latest trends in the legal industry, helping you achieve better results. For the practice of law, the business of law, the future of law, visit BloombergLaw.com. I'm June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.